Welcome everyone again to the University of New Mexico Law and Mental Health Series, weekly discussions of practice and science featuring experts in behavioral health and the law. This series is run by the Division of Forensic Behavioral Sciences of the University of New Mexico's Department of Psychiatry and Behavioral Sciences in support with the New Mexico Behavioral Health Services Division. I'm Anthony Perillo. I'm the Forensic Psychology Training Director here at the University of New Mexico. For our talk today, if you have any questions for our presenter, make sure you enter them in the Q&A box. You can enter those anytime you feel comfortable. Do know that we hold questions until the end, and it's oftentimes not possible for us to get to all of them. If you are pursuing continuing medical education credits, there will be a sign-in sheet that's posted in the chat box shortly. If you are pursuing APA continuing education credits, the link for the survey that you'll complete for those will also be in the chat box, but near the end of the presentation, around 50 minutes after the hour. So make sure you keep your eye on the chat box near the end of the presentation. Bookmark the link if you're not going to open it right now, and make sure you save your certificate after you complete your survey, because we don't have copies of the completed surveys after the fact. If you missed last week's talk in the series, Dr. Maria Apatero-Suedo's well-received discussion of competency evaluations in immigration court is now available on our YouTube channel. The recording for this week's talk should also be available on our YouTube page later this week, and the PowerPoint slides will be accessible for people that registered for the series later this week as well. As a heads up, next week we have Dr. Jamie Anderson discussing psychopathy assessment in forensic settings, including considerations toward a dimensional assessment perspective. But getting back to this week, I'm very excited to introduce you to today's speaker, who'll be discussing risk management considerations in forensic evaluation. This is Dr. Marc Martinez. Dr. Martinez is a psychologist licensed in Indiana and New York with authority to practice interjurisdictionally through PsyPact. He achieved board certification in forensic psychology from the American Board of Professional Psychology in 2011. Since 2012, Dr. Martinez has maintained a private practice specializing in forensic psychological consultation and evaluations relating to civil and criminal matters. Aside from his private practice, he also serves as an ethics and risk management consultant for the Trust's professional liability insurance program, and he's been doing that since 2020. He's also contributed to the field through publications and presentations on topics related to forensic psychology and ethical practice. He's held various leadership roles with professional organizations, including president and treasurer of the American Board of Forensic Psychology, chair and vice chair of the American Board of Professional Psychology's Ethics Committee, and chair and vice chair of the American Psychological Association's Committee on Professional Practice and Standards. So Dr. Martinez, Marc, on behalf of the University of New Mexico, thank you so much for joining our series, and we're very much looking forward to sharing your expertise with us today. I'll go ahead and toss it over to you.
Great. Well, thank you very much for having me. So before I begin, I want to make clear that the views expressed in this presentation are mine, and they do not necessarily represent the views, policies, or positions of the University of New Mexico. I also want to disclose that the Trust Professional Liability Program employs me as a risk management consultant, and my consultation services are offered to policyholders through the Trust. Aside from this affiliation, I don't have further conflicts of interest to disclose. And lastly, it's important to know that the information I provide does not constitute legal advice. If you are seeking legal advice, please seek an attorney in your jurisdiction. And as you'll see as we move forward today, obtaining legal advice is a fundamental risk management tool. Today, I'll strive to meet the following objectives. Ideally, by the end of this presentation, you'll be able to describe 3 general sources of risk relating to forensic evaluations, identify 3 general strategies for managing risk, and be able to list at least 2 strategies for managing requests for test materials by attorneys. And before I jump in, I'd like to take a moment to acknowledge Dr. Joe Scropo, who's a psychologist and attorney, and also a fellow risk manager at the Trust, for his contributions to this presentation. So let's start with a basic question. What is risk management? In essence, it involves future-oriented thinking that allows for examining various decisions retrospectively. This involves routinely asking yourself, what can go wrong? Why? And what are my options for avoiding or mitigating these problems before they actually become a problem? In this way, risk management is like a process of violence risk assessment in forensic psychology, which many of you, I'm sure, are well versed at. And in that way, you would consider past, current, future risk factors, and then create a plan for managing or mitigating that risk. So by instituting risk management in our practice, this allows us to be forewarned so that we can be forearmed. In doing so, we improve our ability to identify and provide services that are consistent with standards of care and best practice methods. It also increases the likelihood that we'll be able to demonstrate, should questions arise or an unfortunate adverse action occur, that our decisions were reasonable, competent, ethical, and prudent. Risk management is often a melding of business decisions and ethical principles and standards. You may notice as I go forward, as I've already done up to this point, that I refer to both principles and standards. I find that it's often the case that principles, such as those that are detailed before the specific standards in APA's ethics code, are overlooked or their values perhaps not fully appreciated. This tendency, I believe, is often because the standards are more clearly operationalized. And as such, they're often easier to apply to practice situations. However, there's certainly many scenarios in which these standards may not apply or don't clearly apply, and they leave us wanting more. So in these cases, I find it often valuable to look to the principle for guidance, refocusing from the specific to the general. And in a way, you could liken this process to studying the forest rather than focusing on the trees. So what are the primary risks facing mental health professionals? The first two I'll discuss are licensing board complaints and malpractice suits. It's important to recognize that we're much more likely to get a licensing board complaint relative to a malpractice lawsuit. Partly this is because it's easier to file a board complaint simply going online, and also it's free. In terms of a board complaint, the consequences can range in severity, as being required to obtain additional continuing education, to the more severe penalty of losing your license and as a result, likely your livelihood. Malpractice consequences, on the other hand, are most commonly monetary. And while they can be significant, they're less frequent. And if limited to a malpractice suit, you still retain your license and your ability to have a livelihood moving forward. Another risk that we face involves negative reviews. Now, in the age of the internet, these are often online reviews. Because of the nature of our work and the confidentiality obligations, we cannot respond in a way that other businesses can. As such, navigating this type of a situation can be challenging as you seek to protect your professional and business reputation, while also honoring your commitment to maintaining confidentiality. Next, we see insurance audits. Now, given the topic of today, which is forensic evaluations, this is not likely to apply. But it's important, if you do find yourself accepting insurance in some way for your practice, that you remain sensitive to the increased number of insurance audits, which is likely due to concerns by insurance companies over increased telehealth fraud. So if you do find yourself in that situation, the best proactive approach is to look over provider requirements outlined in your contracts, and if necessary, check with the insurance companies that you're in network for to understand your obligations as it relates to medical necessity, those standards, making sure you meet them. Your record keeping is in line with their expectations, and your billing practices are as well. The last central risk of clinicians relates to ethics complaints. And these are less common now because ethics committees now typically operate differently. That is, in a consultation role rather than an enforcement role. So when ethics committees receive ethics complaints, it's now more common for them to direct the complaints to the licensing body. I'd now like to shift gears and discuss some general sources of risk to consider in your practice. The first is client-based, or for those for whom you're providing services. In forensic practice, this is often different than the evaluee and maybe a court, an attorney, or another party. It's essential at the outset to clarify who the client is. To do this, ask yourself, am I clear on who the client is in this matter, who will control access to the evaluation information and make those vital decisions about the evaluation. Next, you want to make sure you clarify what the client is seeking, clarify what they're looking for, what they want to accomplish with the evaluation. Consider how invested they are in a particular outcome, conclusion, or recommendation, Are these realistic? And what would happen if you didn't meet those expectations? Next, let's consider the evaluee, what they bring to the situation. And this may be in the form of certain personality traits that could increase the likelihood of a negative action, which is a board complaint. This is often heightened, unfortunately, in evaluations, generally in forensic evaluations, if there's an unfavorable finding. Consider the evaluee's risk for self-harm, harm to you, harm to others, even substance abuse or history of involvement in lawsuits or other legal disputes. Also consider whether the evaluee is appropriate for the evaluation format, such as telehealth versus an in-person evaluation, or brief versus long duration evaluations. And of course, it's important to consider your own personal risk. Critically review your knowledge, skill, and experience relevant to the case in focus. Consider conflict that might impair the delivery of your services, such as pre-existing relationships with the client or someone close to them. When I began my practice, I was often contacted by close friends who became attorneys who would inquire about my availability to assist them with a case. Because of the clear threats to objectivity in that type of a situation, I consistently declined those assignments and referred them to experienced colleagues who could assist. Also consider biases that are likely to be present. Of course, that's much easier said than done, given our inherent blind spots. But as we move forward today, we'll discuss some strategies that will increase the likelihood we can gain insight into our biases and strive to mitigate their effect. Then lastly, consider situational risk. That is the context of the work that we're doing. This could involve court-ordered versus privately retained work, or even say routine cases versus those that are more high-profile or complex. And the overarching goal of general risk management tools on this slide that I'll provide to you is to foster a reflective rather than a reactive approach to ethical dilemmas and risky practice situations. So in other words, they foster our ability to make haste slowly. That is to proceed expeditiously but prudently. In my experience, the most essential risk management tools available include a comprehensive and detailed informed consent or notification, as well as service agreements that are spelled out in clear, understandable language. Consultation, also documentation, and the use of structured decision-making tools or methods or models to aid us in slowing down and giving thoughtful consideration a challenging situation and potential solutions. As a starting point, I'm going to reiterate this as we go through, as you'll see, important to remember to slow down. As a risk management consultant, I receive a lot of calls from colleagues who tend to react impulsively to challenging situations because they feel some sort of pressure to act, or perhaps anxiety, they respond to it. In reality, few situations that we're faced with are true emergencies where we have little time to reflect and must react. By reminding ourselves to slow down and strengthening that muscle, we're more likely to shift into a reflective rather than reactive mode. And because a slower reflective approach permits us to better access our emotional experience and intelligence, akin, of course, to some of the ideas of mindfulness and reflection, as well as Daniel Kahneman's System 2 cognitive process. For many, the challenge is how to do this in our often demanding and fast-paced practices, and in general, our lives. So the questions and the examples that follow on the slide pertain to self and situational assessments that will hopefully provide a good starting point for obtaining important information at the outset of an evaluation to ensure that you accurately identify the client and determine your fit for the case. As a first step, of course, clarify the referral question. Just simply put, what am I being asked to do? And next, and unfortunately, sometimes neglected consideration, is determine who will control access to the record and the evaluation information. Now, this will largely depend on the nature of your practice and the case. So for instance, the individual seeking services may control the legal guardian of the evaluee, or the retaining attorney or even the court. Next, determine whether you have the necessary competence to provide the services necessary to address the referral question or questions. And this is typically going to be based upon your training and experience. And I appreciate that it's sometimes challenging to answer this, given many of us, especially, have an incurable case of imposter syndrome, meaning that we may underestimate our skill set and shy away from cases we are competent to accept. Of course, the opposite is also sometimes true. That is, I think we're all have met somebody who sees themselves as competent, everything psychology may touch. So my recommendation is to picture yourself defending your training, experience, competency to a board, licensing board, and answering the question, what makes you competent? And then after you're done making your argument, change places and evaluate whether you would be convinced. Alternatively, I also recommend seeking consultation with a well-established expert in the area where you're seeking guidance on your competence. That expert may be willing to review your training and experience, perhaps even review a redacted sample of your work, or assess your abilities in other ways to give you feedback on your readiness to practice in the area independently. Next, consider applicable laws. Am I familiar with relevant state and federal statutes as well as case law that may be applicable in this jurisdiction or to the case at hand? Again, try to think jurisdiction and referral question specific with this. If you're at a loss for how to find this information, it can often be obtained from the retaining attorneys or colleagues or professional organizations. Next, consider ethical standards and principles. Also extend this to professional practice guidelines. These are, of course, aspirational in nature, and they're intended to provide context to the ethical standards and principles, such as relevant to today, APA specialty guidelines for forensic psychology. It's also important to make sure that you're sensitive to the fact that not all states adopt APA's ethical standards, and they may have more nuanced or different approach to their ethical standards and what they obligate you to do. Review your documentation practice. For example, where do you retain your documentation? How? What level of detail is appropriate when you're creating documentation? I suggest increasing the detail of your documentation as your exposure to risk increases. And also remember that relevance is an important guide to anchor the details that you do include. Yeah. Important to ask yourself, what and with whom should I consult? For example, experienced colleagues, legal professionals, state agencies, accountants, perhaps. Also consider an ethical model to analyze the problem, such as the CoreOpt model that was offered by Bush and colleagues back in 2020. And I'll be discussing that in more detail as we move forward. As the last example, ask yourself what information should be included in your service agreement, informed consent, and notification. A great starting point for this, if you don't have this documentation already, is to get some samples from experienced colleagues, perhaps your professional liability insurer, professional groups, and make sure that it's specific to applicable practice areas and jurisdiction specific. And even if you have this documentation already, it's a good idea to routinely revisit and make sure that it's up to date. So I'll now focus on informed consent. As I'm sure many of you are aware, informed consent is a tool that sets the foundation for what to expect in the professional relationship. And creating this document fosters a slow and thoughtful approach to setting expectations at the outset. And so while it's important to deliver before beginning services, it's just as important to revisit throughout your professional relationship with the services you're providing as the focus or modes change or as needed. So it should be a dynamic process, that is informed consent or notification, rather than a one-time obligation that you check off and move beyond. And you'll notice I really want to stress the role of process, because it's crucial that you do not sacrifice the process because of efficiency given more value. Personally, I've had countless experiences, whether it's going to the dentist or the general practitioner's office, where I'm simply asked to sign a pad that relates to an informed consent or any other type of documentation. And there's no discussion. In some cases, I don't even get a copy of it unless I ask for it. So this does not send the message that it's important, and it runs the risk of misunderstandings that can be costly later. And when I have this conversation with callers during consultations, I'll frequently remind them of the time that we exist in which if you download an app, how many of you have thoroughly read through the terms of service before clicking accept? And the last thing you want to do is put informed consent or notification on the back burner as though it's not important, and just have somebody simply accept or move forward, because we may be missing a very important opportunity to clarify misunderstandings and save us some risk down the line. So even again, for those of you who are very experienced, periodically review the information in your informed consent or notification. That's also a good way to reinforce its importance. Now, the suggestions I provided on this slide, provided by Kalmbach and Lyons in 2006, they serve as a framework for an informed consent or notification. And in addition, consider language about limits of confidentiality, state-specific requirements or case-specific information that would be helpful. And lastly, be mindful of how informed consent differs from notification in a court-ordered evaluation due to the reduced role of voluntariness. Now, a service agreement is a document that formalizes expectations between the evaluator and client prior to the evaluation. Content serves as an example of how some of the information to consider when you're creating a service agreement. And note that this is most commonly used when retained by an attorney or agency rather than appointed by a court. But even if appointed by a court, the information may be helpful to discuss at the outset of your relationship, particularly if it's a new relationship. And again, consistent with our overarching objective in risk management, creation of this document allows us to slow down and set appropriate expectations. The consultation with other professionals is an invaluable resource at all stages of practice, especially when used routinely. It's also another valuable and effective way for slowing down. It can be used as a way to maintain a stance of humility that serves as a check against our blind spots and biases and competence drift. It allows us to acknowledge and remind ourselves and colleagues of the importance of being what I like to call a forever student. That is, being open to continuous and lifelong learning. And before moving on, though, I want to make sure to offer caution as it relates to those with whom you consult. Be selective. To me, an ideal consultant will be a well-established, experienced, critical thinker who's not afraid to provide direct feedback, but also remain supportive and constructive. You can find a consultant like that. I really think that would be an important relationship to foster. Be cautious about accepting direction from those who you're not familiar with, perhaps unsolicited advice or advice that you may see on listservs. If you do get that information, just like any other information, you want to make sure that you vet it, because ultimately you're the one who has the responsibility for determining whether to accept or reject the recommendations of the consultation you receive. Now, in terms of consultation, literature, of course, is also vital and should be incorporated routinely. This include, but it may not be limited to, laws, both state and federal, case law, rules of evidence and procedure, ethical principles and standards, professional practice guidelines, even state advisories, such as those relating to telehealth delivery. And next, when I refer to documentation, I'm essentially referring to good record keeping strategies. I strongly recommend using documentation to memorialize not just your conclusions, but your thought process. In other words, capturing what was done and why. And in this way, you create documentation, you develop documentation in a way that's not just there to memorialize conclusions, but it can be a tool in your analysis process. And again, as I said before, consider relevance as a guide to the content of your documentation. And last but not least, as the tools that I've discussed, I recommend using a structured ethical decision-making model if you're not already using one. particularly when navigating challenging ethical and risky practice situations. Now, there are several to choose from. I've highlighted Bush and colleagues 2020 core opt model, but it's important to highlight that there are several others. Kucher and Keith Spiegel, 2016, have a model, as well as Pope and Vasquez in 2016. But today, because of the nature of this talk and its focus on forensics, I've opted for Bush and colleagues core opt model. The intent of this model is to assist with navigating ethical dilemmas through organized steps of analysis and assessment of selected outcomes. Now, the model's first step involves clarifying the ethical issues present. So what are the ethical issue or issues? What is or may cause a potential conflict with ethics? Next, you want to determine who are the stakeholders and what are my obligations to them. Also, consider the references that can inform you about the presenting issue or issues. This could include ethics code, practice guidelines, research articles, or even knowledgeable colleagues. Next, you want to examine personal beliefs and values, an honest, critical self-appraisal. Ask yourself, how might my values, beliefs, and experiences affect my decisions in this situation? For example, if someone was scolded by a colleague for addressing a confidentiality breach in an informal way, they now may be hesitant to engage in informal resolution for future ethical issues. So this is, as I referred to before, given the blind spots that we have when we're doing a self-appraisal, this is an area that certainly could benefit from a trusted and critical consultant to consider that information as we engage in a self-assessment. Next, we want to strive to identify as many possible solutions to the problem. In other words, brainstorm as many solutions. No idea is a bad idea at this point. And then the next, putting that plan into action. Ask yourself, how would I rank order the possible solutions that I came up with? Which one appears to be the best among the alternatives? Now, unfortunately, there may be many cases in where there's not a clear winner, and you're going to be stuck with selecting the option that is likely to provide the relative best outcome. And then the last step in this core opt model is to take stock, evaluate the outcome and revise as needed. So in other words, did this approach result in a positive outcome? Do I need to consider other solutions to the problem that remained? Was there anything missing or that could have been improved during this process? And what did I learn from this experience that may inform similar situations in the future? Additionally, while discussing structured decision-making process to ethics and risk management, I find the following framework I learned through Randy Otto helpful. It differentiates between those aspects of our practice that are mandated, such as reports of child abuse, and those that are prohibited, such as sex with clients. Now, these are on the extremes of this continuum. And there are those that fall in between, such as those things that may be permitted and are advisable versus those that are permitted but not advisable. So consider, for example, entering into a professional relationship where there's an absence of a strong, clear conflict of interest, but instead there are nuances or an appearance of a conflict. And one could argue that that's not prohibited or banned, but maybe it's inadvisable, but it is permitted to practice and move forward in that way. I think one of the bottom lines of this thought process, the way that this is structured, is if you're going to call something unethical, it should be ideally beyond dispute or something you can reasonably defend that points to something that was not done or something that was prohibited that was done. Otherwise, if that can't be supported, you may be talking about something that was permitted but not advisable. Of course, if you're not sure where things fall, this is a perfect opportunity to consult documents and use the structured decision-making model. So at this point, I'd like to turn to an example of how this information may be applied. And I'll start by focusing on a scenario involving requests for test materials. So in this scenario, Dr. Farley recently completed his forensic training, which included conducting competency to stand trial and criminal responsibility evaluations. Upon completing his training and obtaining licensure, he established a solo forensic private practice. One day, he was contacted by a local court and asked to conduct a court-ordered criminal responsibility evaluation. Eager to establish a relationship with the court, Dr. Farley accepted immediately, and the court appointed Dr. Farley to the case. While reading the few records provided by the court, Dr. Farley learned that the case was a high-profile case in the local community and involved a litigious defendant who was accused of sexually abusing a female child stranger. He felt very disturbed by the graphic nature of the offense and struggled to keep his mind from thinking about his own young children who were similar age to the alleged victim. Prior to the evaluation, Dr. Farley sent the evaluee a copy of an informed consent, which the evaluee signed and returned prior to the evaluation date. Then on the day of the evaluation, Dr. Farley asked the evaluee if he had any questions about the informed consent. And when the evaluee said he did not, Dr. Farley proceeded with the evaluation, which involved a clinical interview and various psychological tests. Dr. Farley noted that the evaluee was quite guarded through the evaluation, providing limited information during the clinical interview, and also some indications of possible exaggeration on testing. Again, eager to impress the court, Dr. Farley completed his report within 24 hours of completing the evaluation, settling on an opinion that was unfavorable to the defendant. A week later, he received an email request from the defendant's attorney demanding all evaluation material. Now, Dr. Farley had never dealt with this type of situation before and was not sure what to do. But given the stern tone of the email, Dr. Farley felt intimidated and reacted by providing a copy of the entire evaluation file, which included reviewed records, notes, billing, and psychological test material. Now, let's start by identifying some potential hazards in this situation. Now, I'm sure many of you are thinking there are a host of hazards we could explore. I wouldn't disagree with you there. Well, let's consider the general sources of risk reviewed earlier to identify and categorize some of the hazards to come across in that scenario. So in this scenario, the court is the client. So associated risks include Dr. Farley's appreciation for the court's control of the evaluation information, possible misunderstandings due to a failure to clarify expectations of the court, such as Dr. Farley's experience, fees, timeline, even availability. And as noted, the court provided few documents, and Dr. Farley did not clarify whether more relevant documents were available or develop a plan for how to obtain them if they weren't readily available from the court. In terms of the evaluee, risks include, well, Dr. Farley learning that the evaluee has a history of litigiousness. He also obtained information suggesting that the evaluee is guarded and possibly exaggerating the presentation. And that in and of itself limits the amount and quality of the self-report information obtained by Dr. Farley, which, in light of the limited information provided by the court, be problematic when trying to formulate conclusions. As for personal risk, Dr. Farley is relatively inexperienced and new to independent practice, something you can't get around, and one thing that many of us probably experienced at some point in our career. His eagerness to impress the court likely caused him to respond on several occasions without thinking things through, and is writing a report without seeking additional collateral information, especially given the guarded approach, potential exaggeration, and limited records. Dr. Farley also failed to consult about how to handle the defense attorney's demand for records. Now, there's also a potential conflict of interest here that undermines Dr. Farley's objectivity due to his reactions to the case materials. Also, there's evidence of insufficient notification process prior to starting the evaluation. In fact, the use of informed consent given a court-ordered evaluation. There is evidence suggesting Dr. Farley did not allow for sufficient time to formulate opinions and to obtain sufficient information to support those opinions. And additionally, there's no indication that Dr. Farley determined whether there are state laws in this jurisdiction that govern the release of test data or material. In terms of the situation, this is a court appointment rather than retention by an attorney, which is meaningful, especially with regard to identifying the client. The case, as I said, is high profile, meaning that the likelihood of scrutinized work and adversarial exchanges are likely heightened. And the demand by the defense attorney left Dr. Farley feeling intimidated and uncertain. So clearly, there are many missteps in this situation. I would not disagree with you if you're thinking risk management strategies also at this point are like closing a barn door after the horse is bolted. But regardless of all of that, we have to ask ourselves, what now for Dr. Farley? Well, while there are many issues from the scenario I provided that we could focus on, let's focus on the records being turned over to the defense attorney and apply the steps found in the core opt model. So first, what's the ethical issue? Well, the ethical issue here is the inappropriate sharing of information that's controlled by the court client without the court's authorization, and perhaps even contrary to state law that may protect test data and or materials. In terms of the stakeholders and obligations, stakeholders in this scenario involve the court, the attorneys, the evaluee, arguably contractual obligations to test publishers regarding the protection of test materials, and also ethical obligations to the field for test security. Next, what references can provide information about the presenting issue? Examples include APA's ethics code, specifically looking at 9.04 and 9.11 as they relate to test data and test security issues. Also, APA's specialty guidelines for forensic psychology, particularly guideline 8.01. Other sources include ethics committees, liability insurance carrier risk management consultation, experienced critical thinking colleague, as well as recent articles, several recent articles, including APA's Committee on Legal Issues, as well as those authored by forensic psychologists and neuropsychologists practicing in forensic role. Next, Dr. Farley felt intimidated by the defense attorney, having no previous experience of dealing with such an aggressive legal professional. Dr. Farley had relatively little experience of navigating complex third-party evaluations where determining who has access to or control over evaluation information was central. Dr. Farley, turns out, was under the impression that APA standard 9.04 regarding test data governed test material disclosures, meaning that once the test materials included the evaluee's responses, Dr. Farley believed they became test data, thereby being subject to release without any type of ethical problem. And this was a mistake. Dr. Farley hoped to make the matter go away by cooperating without delay or challenging the defense attorney's request. And at this point, let's assume Dr. Farley considers as many options as possible and puts them on the table. Dr. Farley may consider leaving it alone, hoping for the best, perhaps contacting the prosecutor and providing them with the same information, or requesting the defense attorney return all records provided, or requesting the defense attorney return the test materials only and that they exchange all testing information for redacted copies that retain only test data and remove portions contained in protected test materials. So in terms of putting a plan into place, let's assume that ultimately Dr. Farley decided on contacting the court, informing them that there was a misstep and offering some remedies, such as having the defense attorney return all of the evaluation material or just the testing information without making any copies. And then with the court's authorization, of course, and assuming that this is permitted in state law, providing the defense attorney with redacted copies to just test data, leaving out test materials, or alternatively providing unredacted copies of the material and data to another psychologist. So pursuing this plan, Dr. Farley spoke with the clerk of the court and informed them of this plan. The clerk then passed this on to the judge overseeing the case, and the judge emailed Dr. Farley. After initially expressing frustration about the disclosure, the judge identified it as a simple mistake by Dr. Farley and noted that the defense attorney is well known for bullying tactics such as this to previous psychologists who have responded in a similar way. The court, because of this history, decided to contact the defense attorney to chastise their conduct and departure from proper legal procedure, and directed the defense attorney to return all evaluation materials immediately and destroy any and all copies made or risk being held in contempt of court. Dr. Farley received the evaluation information provided by the end of the week and informed the court of this development. And at this last step, in terms of taking stock, Dr. Farley considered the record release situation. I felt that the selected option had a positive outcome, fortunately, and he was relieved that this option, rather than the others, the brainstorm was selected. Unfortunately, Dr. Farley also understood at this point that this did not resolve the situation entirely, because during this process, Dr. Farley learned about his many mistakes during the evaluation process while consulting with the former supervisor. This included the limited basis used for forming opinions, the possibility that his reaction to the material viewed may have undermined his objectivity. And so knowing this, Dr. Farley returned to the core opt model for each issue, and through ongoing consultation with his former supervisor and local ethics committee, decided to request additional time from the court to obtain and consider additional materials relating to the case and submit an addendum reflecting these additional consultations. Ultimately, the court granted Dr. Farley's request, provided orders that permitted him access to the evaluee's treatment and jail records. And following from this point forward, Dr. Farley also obtained ongoing consultation and continuing education to improve evaluation procedures, ethical conduct, and understanding the legal process. So for the second scenario, I'm going to be focusing on a complicated mandated reporting situation, pulled from the situation that has occurred during consultations some years back. So in this situation, Dr. Paris is licensed to practice independently in Indiana. She was retained by a local public defender to conduct a sexual risk assessment of their client. Dr. Paris signed a confidentiality agreement with the public defender's office prior to reviewing relevant records and conducting the evaluation. After the informed consent process, the evaluee provided Dr. Harris with details about neglectful conduct allegedly committed by a specified family member against the alleged victim in the pending case. Dr. Paris took note of the information provided by the evaluee and completed the evaluation. After the evaluation, Dr. Paris was faced with a dilemma about what to do given the presence of a confidentiality agreement with the retaining attorney and mandated reporting obligations in the state of Indiana. So using the core opt model, Dr. Paris began by clarifying the ethical issues. And there were a host. Dr. Paris identified maintaining confidentiality, grounds for disclosure with and without consent of clients, avoiding harm, the principles of beneficence and non-malfeasance, and also the principles of fidelity and responsibility, and of course, the issue of informed consent. In terms of obligations to stakeholders, Dr. Paris identified the retaining attorney, evaluee, and alleged victim as primary stakeholders in this situation. In terms of resources, Dr. Paris reviewed Indiana's child abuse reporting statutes, which state a mandated report is required when an individual, not necessarily just certain professionals, an individual who has reason to believe that a child is a victim of child abuse or neglect will make a report. And Dr. Paris noted that there were no exceptions relevant to the situation in the statute for reporting. Dr. Paris then obtained a de-identified consultation with two Indiana Department of Child Service representatives, both of whom reported that this situation would require a report. Dr. Paris also consulted with experienced colleagues and a local healthcare attorney who all shared the opinion that a report was required. Next, Dr. Paris considered personal beliefs and values to include the importance of protecting the professional relationship with the client, public defender's office, as well as the importance of protecting child from possible abuse and neglect, and also the importance of maintaining confidentiality unless it's overcome by some exception. Dr. Paris formulated several options to resolve the situation. These included reporting to DCS immediately, informing the retaining attorney about the need to report before making the report to DCS so that they're aware of the situation. And last option that Dr. Paris considered is only reporting to DCS after being approved by the retaining attorney. In terms of the action plan, based on the consultations received, the ethical standards and principles identified, and the legal standards in Indiana, Dr. Paris decided to inform the attorney about the report prior to making the report. Unfortunately, the retaining attorney was not available at the time Dr. Paris attempted to contact them. Based on the requirement in Indiana to report immediately, Dr. Paris did not want to delay the report any further, uh, given that she had already taken some time to consult. And so Dr. Paris made the report without having an opportunity to inform the retaining attorney first. Once the report was made, Dr. Paris emailed the retaining attorney about the report and its basis, and made sure to document each step in detail, as such as the consultation received, the ethical standards and principles identified, mandated reporting standard, and making sure to capture a full analysis of the information considered and what led to the ultimate decision to report and the steps taken. Now, the day after the report, the retaining attorney and the chief public defender requested a Zoom conference. During this conference, they cited the Indiana rules of court, which are consistent with the American Bar Association's model rules of professional conduct. And this related to their rule regarding confidentiality of information, the standard asserting that they and the psychologist should not have reported the neglect, adding that the psychologist in their work falls under the attorney-client and work product privilege. The chief public defender expressed concern about Dr. Paris's breach of their agreement by disclosing the information shared by the evaluee, noting that other experts they had worked with would not act in the same manner, adding that they also may not be able to work with Dr. Paris in the future as a result of this act. Now, Dr. Paris, in a non-defensive but assertive manner, noted the mandated reporting statute language in Indiana that applies to all individuals without exception, and with no exception specifically for attorney-client privilege, as well as the steps taken to clarify whether a mandated report was present before making one. Dr. Paris acknowledged the apparent conflict between the attorney's guidance under MRCP, that's the model rules of professional conduct through the ABA, and the legal mandates in Indiana, as well as the confidentiality agreement signed, but reaffirmed their legal and ethical obligation to report when the standard for reporting is met based on good faith professional judgment. Also noting that one cannot contract to engage in unlawful conduct by failing to report, which was a citation that Dr. Paris was advised to mention from a local healthcare attorney that was consulted. After the dust settled, Dr. Paris took stock to evaluate the outcome. And while disappointed about the potential loss of a referral source, Dr. Paris felt confident that the situation resolved in a manner that was consistent with both ethics and the law. During the last step of this core off model, and that is about taking stock and considering revisions, Dr. Paris incorporated the following improvements into her evaluation procedures with a new appreciation for addressing potential problems in advance. So with this in mind, Dr. Paris decided to provide a service agreement to all retaining parties to ensure that they understood both her ethical and legal mandates that must be followed. Prior to incorporating this into practice, Dr. Paris made sure to have this document, the service agreement, reviewed by local legal counsel to make sure that it was legally defensible and consistent with the applicable jurisdiction. If the retaining party's procedures didn't permit them to sign a service agreement, or let's say they had their own, Dr. Paris's plan was to provide a copy of her service agreement for information purposes only, and ensure that the contents of any agreement they put forward, the retaining party put forward, contain the necessary information. such as jurisdiction-specific mandated reporting obligations. And if these were lacking, Dr. Paris planned on pursuing amendments prior to accepting the case. And if not possible, Dr. Paris is prepared to decline the case and provide referrals. Dr. Paris is also prepared to continue, as we saw in this example, to document all the steps taken in detail for each of these cases to make sure that not just the conclusion is memorialized, but also the process that was followed and the rationale for it, should any questions arise. Now, I know that I've gone through quite a bit of information. I've applied to a couple scenarios, and hopefully you can see the themes that have come out of this risk management approach that I've discussed. And with this, it will conclude my talk, but what I hope is that this presentation contained information that in some way will be helpful to you, your practice, especially as it relates to challenging situations that test the boundaries of your competence and ethical practice. Above all, I hope that you remember the value of taking it slow, which is aided by incorporating the basic risk management tools at each of your disposal and discussed throughout this presentation. And just a reminder, these include incorporating a detailed informed consent or notification, as well as service agreements, utilizing consultation routinely, using documentation, not just as a method for memorializing your endpoint, but also as a tool during the process of analysis and a way to show what you did and why, as well as what you did not do and why. In other words, remember back in the days of school when you take that math test, it wasn't enough to just write down your answer. The teachers wanted to see your thought process, how you arrived at that conclusion, that answer. Treat your documentation in the same way, especially as the risk of your situation increases or the uncertainty increases. And then finally, as we use today, incorporating a structured decision-making process will be invaluable to aid in your analysis as you navigate challenging ethical and risky situations. So at this point, I thank you very much for your attention and the opportunity to present. And I think at this point, you may be able to take some questions. And I will say before we jump into the question portion, if we could stay focused on the content here, kind of the general framework. If you do have specific risk management consultation questions you'd like, those are best for an individual consultation. You can either call either your colleague or contact your professional liability carrier. That'd be the best way for those to be addressed.
Thank you so much, Dr. Martinez, on that very thorough and supportive approach to understanding how we can go through effective risk management and consider the ethical considerations of the forensic work that we do. I think this framework and the reminder of being patient and thorough in these decisions. And oftentimes we have more time than sometimes internally. Our internal pressure to get this off of our plate and resolve it can make us haste through some of these decisions when oftentimes we have time to actually process. And I think that's reassuring to a lot of the early career professionals here in particular. So thank you for that. We do have a number of questions so far. What I have seen is primarily general. So we do have several general questions here on risk management concerns. In the meantime, if you have any additional questions for Dr. Martinez, you can go ahead and enter those in the Q&A box. In the chat link shortly will be the link to the CEU survey. I believe our IT person will be getting to that very shortly here into the chat box. So keep your eye on that chat box there. Some people were asking about limitations, boundaries related to that raw testing data, those sharing limitations in particular. Somebody said, I was wondering if you could talk more about raw testing data in standard 9.04, specifically how broad is psychologist notes and recordings concerning client-patient statements and behavior during an examination. I've seen some people say this only includes information observed, gathered during the administration of the assessment measures, And some people have interpreted this as broadly as all notes made during any evaluation, regardless of testing. What is your perspective?
Yeah, I do think that there are different perspectives and schools of thought on this, but I think most commonly when you're thinking about, say, an evaluation, it's going to be the basis of your opinions. And usually, if you're obtaining some sort of record, whether that's a prior evaluation, testing records that you're reviewing, or treatment records, that's going to be relevant in some way. You've considered it, you're reviewing it, whether it's relevant or not to your opinion. And so I would consider that test data that helped inform your opinion. I do think that APA tends to be a little bit more restrictive because I think in the way that they wrote this standard, it is more focused on actual testing. So it could be an academic discussion or debate about what exactly it relates to test data, what informs your opinion versus specific to testing. On that testing issue, as APA lines it out, I think that there is some confusion, and I understand APA is reworking the standards as we speak, and hopefully see those at some point in the near future. But you can see how magically test materials, if they touch test data, it suggests that they become test data. And test data, we're told in the standards that we can give those with appropriate authorization. But also, later on, we can see that we are also obligated to maintain test security. So it seems to give two different messages, and I think that leads to some confusion. So when I get this, it's very similar to the thought process that was in scenario number one, where test data, some people are very strict, especially if there's a state restriction on it, follow the state restriction. But if there's not, I think providing test data with appropriate authorization is a reasonable thing to do. I know if I was to get my medical workup and I had blood testing, I wouldn't make heads or tails of potassium levels or you name it, but I still have access to that data. Test materials, on the other hand, protocols, items, stimuli, much different. And we do have an ethical and contractual obligation to maintain their security. And I do believe that there are several tools at the ready that would allow us to navigate and thread that needle in a way that can allow us to be transparent, provide necessary information, while at the same time protecting that integrity of the test.
Wonderful. I think that that in fact answers a follow-up question that someone had asking for that test data
perfect.
versus test material clarification there, especially when you get an order for subpoena requesting test protocol or test data and like where the line is there. So thank you for that. For a court-ordered forensic evaluation, would you recommend using written non-confidentiality mandated report notifications that would be given to the evaluee at the time of the interview in addition to a verbal notification? What are your thoughts on this?
Yeah, I think that this brings me back to that permitted, advisable, non-advisable. I think the more formal, especially in a forensic where, as I say, the low-hanging fruits, what's going to get picked first, you're trying to cover all your bases. Verbal and written is ideal. But at the very least, you want to make sure that you do it and that it's documented in some way at the very least. So I think conservatively, yeah, getting that in writing, jurisdiction-specific confidentiality limitations, and trying to get this across that they understand it is important. Now, I'll add one more thing real quick. With a court-ordered evaluation, remember, we're looking for assent. So if they don't understand it, there still may be grounds for moving forward, even if they don't understand those limitations. But you want to certainly strive to make sure that they do understand them to the best of your ability.
Wonderful. If you have time for one quick question before we wrap up here, since we're at the top of the hour, somebody noted the ethics code says psychologists may not withhold records under their control that are requested needed for a client patient's emergency treatment solely because payment has not been received. Does this apply to forensic evaluations? This person notes informed consents that stipulate reports being released only upon payment in full.
Yeah, I think I'd have to review the standard memory. I need to look at the exact language of that. I think that most commonly when I've discussed that, it tends to be more anchored in treatment. You may have a different type of contractual relationship established with an evaluation that may not follow the same. But I'd have to review that. That's something if you could reach out to me, or set up a call through the trust, I could try to get to the answer more specifically on that issue, but that's something I'd have to dig into a little bit more to make sure I'm not misleading.
Fair. Dr. Martinez, thank you so much again for all your contributions in the area to helping us remain on top of being ethical and mindful of the care we do as forensic psychologists, and for sharing all this info and a framework for us to make ethical decisions in our forensic practices. Thank you so much for all of this information.
Thank you very much for having me.
And that wraps up this week's Law and Mental Health series. Next week, we have Dr. Jamie Anderson discussing psychopathy assessment in forensic settings, including considerations toward a dimensional assessment perspective. We hope to see you then for another great discussion of issues in behavioral health and the law. Till next time.